Good morning, everyone. My name is Henry Green, and I will be the presiding judge for our next case. Other judges who are appearing with me are Melissa Taylor Standridge and Patrick D. McInerney. And our next case is 121065, Kevin Skaggs versus State of Kansas. Appearing for the appellant is Richard Ney, and appearing for the state of Kansas is Todd G. Thompson. This case is set for 15 minutes. And Mr. Ney, I'd like to find out, do you want any rebuttal time?
Yes, Judge Green, if I could reserve 3 minutes of my time for rebuttal.
Mr. Ney, we received a motion yesterday to amend appendix to the opening brief. Could you discuss that a little bit? And then I don't know if you had a chance to confer with Mr. Thompson. We would like to know, do you have any objection? Mr. Thompson, after Mr. Ney explains it, we'd like to know if you have any objection to this motion.
Yes, thank you, Your Honor. Unfortunately, Mario Merrills has been before this court about 6 or 7 times. We cited in our brief, and that's what we meant to cite, his 2010 case before this court. We, in the appendix as required, we attached the unpublished opinion, but we attached the unpublished opinion of Merrill versus State 2015. So we're not altering our brief at all. We're just informing the court we sent you the wrong case, the 2015 State Merrills versus State, as opposed to the 2010 Merrills versus State.
Thank you. Mr. Thompson, have you had a chance to review that motion? We can't hear you.
Sorry, I had to find my unmute button. I did see the motion. I acknowledge the case. I don't have any objection. I understand what the situation is.
Well, appreciate you very much. Mr. Ney, are you ready to begin your argument?
I am, thank you, Your Honor. May it please the court, Richard Ney appearing for the appellant, Kevin Skaggs. Your Honor, I am asking that this court grant Mr. Skaggs a hearing on his second 1507, a hearing we believe that he is entitled to under applicable law. And I think there are multiple doors that he can enter the courtroom from. This has always been portrayed by his attorney on the second 1507, Mr. Reardon, as a claim of actual innocence. In fact, Mr. Reardon cited the court Vauclair versus State correctly. And this is about actual innocence. The evidence that's being produced now or attempting to being produced at an evidentiary 1507 would exonerate, in our opinion, Mr. Skaggs. The court below, and I want to point this out, unfortunately used the wrong standard in the issue of newly discovered evidence. It used newly discovered evidence, and that's not the standard we're doing when dealing with a Schlupp, Carrier, Beauclair kind of situation. The standard is newly presented evidence. In other words, evidence that was not presented to the jury for whatever reason. It doesn't have to be newly discovered. And we cited case law on that point.
Mr. Ney, I hate to interrupt you, but I know we have limited time, and I just want to talk about, my first question that I wanted to ask was what relief you're seeking, and so you perfectly said, that what you're seeking is an evidentiary hearing, right?
Absolutely.
Okay, so as a procedural matter, this is kind of how I understand the history, and this is probably going to take 30 seconds or so. But the second 1507 had 3 claims: actual innocence based on newly presented evidence, Brady violation, and an ineffective assistance of counsel, because the counsel didn't get the photos and the counsel didn't hire an expert. And then there was an evidentiary hearing, okay, where Your client testified, your client's mother testified, and the court asked, any other testimony that you want to give, anything you want to do? And Mr. Reardon said, nope, this is all we're doing. Mr. Young was not subpoenaed to come to that hearing as a witness. And that was what, goes to that actual innocence. There was no evidence or argument that the state had the photos to turn over. So there was no evidence presented about the Brady violation. And then on the ineffective assistance of counsel, that they didn't get the photos and didn't hire an expert, that kind of relates back to the actual innocence claim. The district court, after a hearing, denied it as successive, okay, and also no manifest injustice.
Well,
And then a motion to reconsider was filed. Okay, so it seems like what you're asking is, and the motion to reconsider, the only new thing in the motion to reconsider is the Bouclair case, if I'm pronouncing that right. So my question is, why do you need a second evidentiary hearing? And well, I guess that's my question. You already had one.
Well, I don't believe the hearing was an evidentiary hearing, nor was it intended to be. I think it was a pre-trial hearing or a pre-hearing hearing, as is often the case with 1507 cases.
But usually in a preliminary hearing, you don't, present witnesses and evidence and,
Well, the evidence, yeah, Your Honor, the evidence, right. But the evidence really was why they couldn't get why the photos needed to be provided. It wasn't about the issue of the photos, because the photos were never obtained. But I think the petitioner's mother testified that she had tried to get the photos. It was really a hearing, in a sense, in a procedural way, about what we've done to get these photos to present to the court.
Okay, so then the next question becomes what is this distinction between knowing about the results of the follow-up exam, which clearly that was at issue in the first 1507, and those are written words that say the hymen is normal, okay, and getting the photos to have, so your expert already said, that based on the the follow-up exam, reading the words instead of looking at the photos. What's the difference between your expert having that? How are you prejudiced by your expert having that and giving an opinion, and then having the expert look at the photos and then testify that the hymen was normal?
Well, the expert never testified. And let me just take one step back, if I could, Your Honor.
Sure.
The court did not rule on the merits of these claims. So
right, because the procedural manifest injustice and successiveness.
Right. So whether you want to call it an evidentiary hearing or not, I wouldn't. I would say it was more a pretrial. But the court didn't rule on the merits.
Right, but the court did allow evidence regarding the manifest injustice and the successiveness, which was based on actual innocence. So Mr. Reardon could have presented anything.
Well, I disagree, because Dr. Young was not presented. His affidavit was there, but he wasn't there. I don't think anyone intended that to be an evidentiary hearing, because the state maintained at that time, Judge, you shouldn't have a hearing. This is successive.
Right, you shouldn't have a hearing on the merits, because this hearing was all about whether or not it's procedurally barred, right?
Right. And the judge then, when the judge heard the reconsideration, he himself acknowledged that these were different issues, that they weren't successive. In his colloquy with counsel, that's very clear. The judge said, it's very similar, but there's a subtle difference in the argument. The argument is Mr. Lober testified at the original 1507, they had seen medical literature had led him to believe that the hymen could be regenerated. And then he asked the court, do you agree that's incorrect, that hymen can't be regenerated? And the prosecutor said, yes, we agree.
Right, but then the court ultimately ruled after that colloquy that it was, that maybe they were different claims, but that there was, let me find the court's ruling, because the new evidence could have been produced at trial with the exercise of reasonable diligence, and then rejected the Brady claim and rejected the actual innocence claim. So,
Right, but that's the wrong standard, number one. The reasonable diligence is the wrong standard for an innocence claim.
well, no, that was an innocence. That's actual innocence based on ineffective assistance of counsel.
Right, but
Because the actual innocence was brought up as a substantive claim and in the context of ineffective assistance of
right,
counsel.
but he's saying that the evidence could have been brought forward. And in
Right.
fact, there was disagreement between Judge Sunby, who heard the first 1507, and Judge Gibbons, whether the photos were provided or not. So there's really been no evidentiary conclusion on that.
Right, but who bears the burden on that?
Well, you have to have a hearing to have the burden.
Well, that hearing talked about how the woman, she could have put the prosecutor on this. Not she. You could have put the prosecutor on the stand and said, did you have them? Did you have the photos? Because it kind of appears to me, implicitly anyway, that the state didn't have the photos.
The judge, in fact, said during that, what we want to call it, hearing, or the hearing on motion to reconsider, yes, I think the prosecutor will have to testify and the defense attorney testify. He said that.
If there's a factual dispute.
Well, there wasn't a factual dispute, clearly, because he was saying we're going to need to have that testimony. But then he ruled he didn't get there to the merits because he said successive.
Okay, and then what would you present at an evidentiary hearing if it went back down?
Well, what would be presented was the fact that Dr. Sinclair gave two completely inconsistent reports.
Okay, but that is something that was at issue in the first 1507.
No, it wasn't. Due respect, what Mr. Lober testified to at the first 1507 was, yes, Dr. Sinclair gave two reports, the January report and the February report. January says hymen is gone. February report, hymen is intact.
Right.
And that's what the photographs would show. The photographs were taken during the February exam.
Right, so the photos don't really add anything, right? Because she says in the second report.
Depends what they show. An expert could say, look, this, as Dr. Young talked about. But let me get to that it wasn't dealt with. Because then Dr. Sinclair testifies at trial. Does she talk about the hymen being intact? Absolutely not. Her entire testimony is the hymen is gone.
Right, but wasn't that because, that in the first 1507, in the first 1507, it was brought up, why didn't you cross-examine the expert about the discrepancy between the first and the second report? So why would we relitigate this in the second 1507?
Because Mr. Lober was exactly 180 degrees incorrect about hymen regrowing. You can take a 5-second shot at the internet, Your Honor, put in hymen regrowth, and you will see site that says it does not.
Right, but we're not arguing that because that's a whole nother issue. The question is, what, he said it was already litigated. It was, the trial counsel said it was strategy.
No, it wasn't. And here's why. Mr. Thompson's predecessor.
But we can't go back to the first 1507 and say it wasn't strategy. We're just looking at successiveness.
Your Honor, it's only strategy if you actually know what you're doing.
But you appealed the first 1507.
Mr. Lober said hymens regrow. I looked at medical literature. We don't know what it was, but they do. We know that is false. The prosecutor argued that in the closing argument. He argued it in the 1507 that the strategy was correct because hymens do regrow. The court bought that, the district court did, and unfortunately, this court bought that.
But why didn't you bring in an expert about the hymen regrowing in the first 1507?
Because
you had an opportunity.
As we raised, Ms. Kurtz, who did the first 1507, was ineffective in not doing that. Everyone just accepted that. I agree. And this court can consider the ineffectiveness of 1507 counsel first time on appeal, therefore the Merrill's 2010 case, the Robertson case. Ms. Kurtz didn't do it. He just says hymen regrows, and everyone said, oh, okay, we get that.
So the gist of your issue here is on 1507 counsel's ineffectiveness.
Yes, but also we're back to innocence. The fact that Lober said it and the court considered it, if it's absolutely false, are we okay with that? Are we really? That this entire decision in the first 1507 is based on false statements, which the prosecutor now admits was false.
But did they appeal the first 1507?
Yes. Your Honor was on the
Who
panel.
represented your client on appeal?
I'm sorry?
Who represented your client on appeal in the first 1507?
Let me look.
Of the first 1507.
Sorry. Your Honor and Judge McEnany as well were on the opinion. He was represented by Rebecca Kurtz, who did the 1507. So she wasn't raising the fact, because I guess she didn't even take a look at a medical book or even the internet as to the issue of do hymens regrow. In the entire decision of the 1507, this court, again, an opinion that two of this panel participated in, says that in his testimony at the hearing on Skaggs' motion, his trial attorney testified he studied medical literature, we don't know what, he didn't say, indicating that a hymen once damaged is capable of regeneration. He said he chose not to challenge Dr. St. Clair's follow-up finding because
I've read the record.
Well, I'm sorry, everybody bought that down the line, but it doesn't make it any more true because a falsehood repeated is a falsehood repeated.
Okay, so just one more question, and then I'll probably give my colleagues a chance to ask questions,
Okay.
or for you to make your argument. Actually, how do those photos? Okay, how do those photos prove actual innocence?
All right. If the photo shows the hymen is there.
But that was in the report. Okay.
But it wasn't in the testimony put before the jury. The only testimony the jury heard was the hymen was gone.
Okay. And that's the basis for your Kerr's ineffective assistance of counsel claim.
Yes. And
okay. But I'm talking about actual, how do the photos prove actual innocence given the testimony and, given the testimony and all the evidence that was presented at trial?
Well, but that's the question that takes place at a hearing. You see,
what are the elements of an actual innocence claim?
Well, that there's exonerating evidence and the jury.
How is it exonerating?
Well, Dr. Young, in his lengthy affidavit, says the physical evidence in this case, particularly the evidence disclosed in the two genital examination, falsifies the statements of sexual activity offered by BS. Those photos are part of that physical evidence. So it absolutely does, the doctor says. And of course, we have to accept that as true, absolutely true.
Right.
But
that's the same thing that her report says, right? And she says it's consistent.
But let's remember, the report was never brought up at trial because Lober said, well, hymens regrow, so the fact there's a hymen a week after there isn't a hymen, and that's basically it, it was a week, 10 days, doesn't show anything. Well, absolutely it does. That's the problem.
Okay, I have taken up a lot of your time, and I appreciate you answering my questions, and now I'm going to give you time to actually present your argument.
Well, I think that constitutes a lot of my argument, Your Honor.
Okay.
But we would point out that I think there is a responsibility, and we've called it the judicial estoppel doctrine under Hargroves, that there cannot be a decision of the courts that it was proved based on false evidence. If we found out, for example, that a fingerprint didn't match or that DNA didn't match, would we be content to say, well, you got to litigate it, you had the chance? Of course we wouldn't. And Hargrove said a court may apply judicial estoppel at its discretion as necessary to preserve the essential integrity of the judicial process. Is there not some flaw in the judicial process that has happened here when we're going to allow a person to be convicted on the testimony of a doctor? And again, that's what she testified, Hyman gone, and the argument of the prosecutor, and then that be substantiated in post-conviction litigation on a false claim that Hyman's regrown. All we're looking for here is an evidentiary hearing on that issue that goes to, if you want, ineffectiveness of post-conviction counsel, Ms. Kurtz, and certainly ineffectiveness of Mr. Lober in just accepting that, as everyone else did. But let's remember that this falsehood, and again, whether it's was unintentional or not, was certainly bolstered by the prosecution. They argued in the 1507 and in their brief to your honors that is correct, that it was correct that Hyman's could regrow. And that's what this court accepted, that. They had no evidence to the contrary, but it was all untrue. This is sort of, but now they say, oh, well, you had your chance. Although we told the court below, we told the appellate court, yes, the science is Hyman can regrow. You had your chance. You don't get a do-over because of that. Well, it's sort of like if you take a football analogy, the defense sacks the quarterback, but are called offsides. Do we do the play over or not? Of course we do. You can't whine to the referee and say, oh, they had their chance.
The fact that how does the fact that the doctor from Children's Mercy came in and in her report said that those two were consistent findings?
She didn't. She absolutely did not.
She didn't say that in her report?
No. Here's her report. Here's the February report. Quote,
okay.
The photographs, quote, show a normal female genitalia with intact hymen. These photos show a different exam finding than noted in our ER evaluation on January 22nd. She says it's
What does it say after that?
I'd have to pull it. I'm sorry. That's all we quoted.
Well, what it says after that is that this is not inconsistent with my finding from before.
But she says it's inconsistent. I mean, those are her words, that it's inconsistent, a different exam finding, Right, but you're taking the quote out of context. Right.
Right.
Okay. I don't know that I am, but then let's get, how is the hymen back? I mean, that's never gone into. The prosecutor, during his questioning of her, asked her about, the signs of sexual abuse. She talks about the notch, and then she says, prosecutor asked her, anything about the absence of the hymen? And she responded, absolutely. So she's saying that the hymen being gone, the absence of the hymen, is evidence. Well, 10 days later, the hymen is there. Huh? Well, Dr. Young would tell you, and I think we could get almost any medical professional say that's not what happens. Because she doesn't say it's torn, she says it's absent. That there's a little fleshy remnant on the posterior, the anterior is gone. And she never testifies at any time during trial to the contents of the second report, the absence of the hymen.
And then the first 1507 was aimed at that, right? That was one of the main issues.
Was aimed at Lober not attacking that. And he said, right. I didn't, because we all know hymens regrow. Well, no, they don't. And you can't make a strategic decision.
Well, he didn't just say that, did he? Did he also say, I didn't want to go into the second report because she's a medical doctor, and I felt like it would harm my client because it would emphasize the fact that this second report did not change her opinion about the sexual abuse.
Well, he did. And under that theory, he says, I'm not going to attack a doctor because she knows more than I do. Well, under that,
No,
well,
well,
that's what he said.
well, right,
She knows-
but he also said what I just said.
Yeah, but he's saying, I'm not going to cross-examine an expert who knows more than I do. Well, then I shouldn't be cross-examining any expert I know.
Because it would hurt my client, because she testified at the end of the day, it would just bring out her conclusion in the second report that no matter what, whether there was a hymen or not, her findings were consistent with sexual abuse. That's what he testified to, correct?
Which was wrong, because it doesn't regrow, and Dr. Young could refute that.
Yeah.
And he didn't consult with a medical expert. Ms. Kurtz in the 1507 didn't consult with a medical expert. Only Mr. Reardon did in the second 1507. So I guess at the end of the day, we've got to sit here and say, are we content with a 1507 that's based completely, and that's what this court based its opinion on. It's what the trial court based its opinion on, what the prosecutor argued. That is.
But you would agree, wouldn't you, that what's before the court right now is just very simply, even though it sounds complicated, but whether or not your client established manifest injustice or extraordinary circumstances.
Yes. And I can't think of a case that is more extraordinary than this one, where courts up the line accepted a false scientific premise. I mean, as we know today, science means something or should mean something. We can't say, well, scientists don't know. That's the wrong position to have integrity in the judicial system. And I think it's significant that the state is now changing horses and saying, at the first 1507, well, Lover is right, hymens regrow. And now they say, when questioned by Judge Givens, oh, that's right, hymens don't regrow. But it was good enough anyway. I'm well out of time. I'd like to reserve some time for a rebuttal. I will.
I used up a lot of questions, so I hope our presiding judge will give you some rebuttal.
I appreciate answering the court's questions at any time. It tells me what you're thinking about. So I'll reserve the rest of my time if I may, Your Honor.
Yes, I will keep your time for rebuttal. Mr. Thompson, are you ready to proceed with your argument?
Yes, Your Honor. May it please the court? Todd Thompson for the state, Lower County Attorney, Appalachia. This is a successive motion. Mr. Skaggs was convicted in 2007. This is now the third time we've been in front of the appellate courts. First with the district appeal on a previous 16-1507, and now the subsequent 1507. The Supreme Court Rule 183D prohibits successive motions, and that certainly applies to this case. This is not only successive in the 1507 today, but this comes after a 1507 where evidence was presented. They're trying to elongate this or basically take another bite at the apple. The previous appellate already argued 15 points on its previous 1507 motion. The issues raised in this are not new, or the issues have not been able to be previously litigated. 1507 states that exceptional circumstances or unusual events or intervening changes in the law that are prevented the defendant from raising this issue is the preceding case is allowing for a hearing in 1 year. And that's from Beauclair. The appellant wants to open the door to successive motions by relying on Beauclair, saying that there's a colorable claim of innocence or manifest injustice, meaning more likely than not, no reasonable juror would have convicted the prisoner in light of the new evidence. And in fact, Schloop says that which similar to Kansas's manifest injustice should remain rare and only applied in extraordinary cases. Yet they are relying on a photograph and a doctor's statements, which are not contrary to what is available at the time of the trial or at the original 1507. They're ignoring the totality of the evidence and what the jury would have said in hearing them making the conviction. These issues could not sway a jury from acquitting Mr. Skaggs. In fact, in Beauclair's case, the evidence was a recanted statement of both the victim and defendant, which is much different here, much different than the issues that the appellant is trying to raise here. The standard for the colorable claim of innocence is more rigorous than just establishing a prejudice, and that's by, once again, Beauclair. So when evaluating the evidence, you must look at the totality, and in doing so, that would include not only the Dr. Sinclair's January examination, but also the February 5th examination. An appellant wants to use Dr. Young's testimony if it only applies to Dr. Sinclair's evidence, which wasn't omitted. Dr. Young's evaluation completely relies on contradicting the February 5th examination of a child. Yet if you use both of the examination, Dr. Sinclair's evaluation only explains the normal course of healing process, which has been noted in her reports. Yet Dr. Sinclair even says that the second examination isn't much different than is different than the January examination, but still shows sexual trauma. One of the things that Mr. Ney keeps emphasizing is the fact that it's talking about regrow, or what Dr. Sinclair, and one of the things that is ignored, in fact, is it actually says normalize. Normalize is different than regrow. And that seems to be missed in the overarching argument. Further, one of the things that's missed in the overarching argument is looking at all of the evidence of this case. We're talking about one significant thing. Once again, the February 5th report wasn't presented to the jury. They heard the January 22nd report, had an opportunity to argue that, and we've already decided in the previous 1507 that the trial strategy of the previous defense attorney Lober was appropriate to not open that up. So we have to look at whether there's a necessary hearing, but in looking at a necessary hearing, you have to look at the entire file, the entire record, and that's not only from KSA 60-1507B, but then also following Beauclair. The sentencing court is not required to entertain a second or successive motion, and we're arguing that this, again, is something that could have and was already argued. And so Mr. Ney is also trying to open that door through a habeas claim that Ms. Kurtz was deficient in her 1507. But Ms. Kurtz actually has already had a 3 to 4 day evidentiary hearing where she had the opportunity not only to put on doctors, but also put on Mr. Lober. She, like I said before, she argued 15 different points. And when you're looking at a deficiency or looking at an ineffective assistance of the habeas attorney, you have to look at the totality of the circumstances. Were they deficient in the objective standard of reasonableness and that prejudice? Neither one apply in that circumstance. She was very thorough. In fact, we wouldn't be still here arguing this if it was not for her thoroughness. And again, Mr. Ney brought to the attention that the court said that these arguments might be subtly, I think it was Judge Gibbons, the district court said there might be subtle difference from the original 1507 to this 1507, but the state would argue that it's not about subtlety, it's about substantial. This is about whether, like Beauclair said, this is about whether there is an exceptional circumstance, unusual event, or intervening changes. The affidavit from Dr. Young and the information presented by Dr. Sinclair are saying the same thing of a normalization. And the reason that Lober did not want to follow up with that testimony was he didn't want to open up the door more so. He didn't rely on false information. I know Mr. Ney keeps trying to emphasize that the state has changed his opinion in order for some type of estoppel to say you can't open the door. But if you actually look at the entirety of the record, the state was not actually arguing one way or the other about whether the hymen could regrow in its statement. It was more arguing about it couldn't. Maybe the state used improper phrasing when saying, sure, it can, but actually said believe or my understanding. You know, the state is not the expert, is not, you know, it is an opinion. If you're going to rely on the state's opinion, we wouldn't even be sitting here right now because the state's opinion is there's so much evidence that Mr. Skaggs is guilty of what the jury found him guilty of, that what Mr. Ney or the appellant is trying to open the door for wouldn't even be material, much less it's not manifest injustice or is not a colorable claim of actual innocence. The young child at 11, she not only told a counselor, but she told a police officer, she told a doctor, and she told the jury all of the facts. And in fact, the appellate court even said that her statements were consistent. Then you look at all the internet chats that Kevin Skaggs has. He admits it's him, he admits his age, he admits where he's from, and then he also admits the same sexual activity that this minor child told all those people. Those two statements are the exact same, and they correlate with the January 22nd examination that Dr. Sinclair had, and even in that January 22nd examination, she talked about how the hymen can normalize, come back, and form some type of skin tags. So,
Mr. Thompson, let me ask you a quick question. So
Sure.
what you're saying is, and if I get this right, under Beauclair, to show actual innocence, you must show more likely than not that no reasonable juror would have convicted in light of the new evidence, and that we need to consider all these other facts that you're talking about
Yes.
in deciding whether or not no reasonable juror would have convicted, right?
Correct.
Okay.
And that would be even that decision would be even if necessary for a hearing. You look at everything and not just, and that's the problem is with the arguments that we keep going, they're going down this, what I would call the expression a rabbit hole. We keep focusing on this little minutia and not looking at the totality of all the evidence that's presented at the trial and all the evidence that was aware to be able to open that case. And if you look at all of that, Dr. Young's testimony, even though it's probably could be considered similar to Dr. Sinclair, it's still not significant enough. And so when in Mr. Ney's reply brief saying, why are we having an argument about, two different experts? We didn't get to that point. We need to have that argument because you have to look at everything in determining the hearing and in determining to opening the case back up. And if you even think about, and just to touch on the Brady issue, one of the, and it was articulated in my brief, but it says that doesn't open, that the doctor is not an agent of the state, and they shouldn't be considered agent of the state. The mother actually took the child there for an examination before contacting any law enforcement, and and we've seen that before. Not to mention the state had never received any of that information and or those photos, and that's been carried on in all these motions and briefs. So we would
And
not
at
have
the
any.
evidentiary hearing in this case, did Mr. Reardon present any evidence that the state was in possession, or did he elicit any?
I don't recall any of that information. I'm sorry,
Okay.
I don't remember that. I don't remember that, but I know that in the initial 1507, there was discussions about the photographs being turned over. I mean, that's been an issue that's already, this is yet again another successive issue. So the only way that you would get into these photographs in this issue is saying that something new has occurred, and that mechanism is closed not only by the Supreme Court 183D, but also Beauclair, because there's nothing new about this issue. And honestly, I don't believe that the photos would have any issue that would cause some type of difference than what already seen by Dr. Sinclair's notes from that. And again, the doctor and that agency is not an agency of the state. So I don't think that there is any Brady violation, because that's the only way that Brady violation is if we had possession or if there's some form of agent. And I think it's a real stretch to try to say that they're an agent. So in summation, if you look at the overwhelming amount of evidence presented at the trial and the information brought forward today, we would not find it be persuasive to a jury to find beyond reasonable doubt that the defendant is not guilty. Their information is not new, and we ask you to review the argument today, the briefs, and the entirety of the evidence to affirm the both district court's decisions that this is successive and does not rise to the level of manifest injustice or a colorable claim of innocence, of actual innocence. I stand
Thank
for
you, Mr. Thompson. Mr. Ney, are you ready for your rebuttal?
I am.
You have your full rebuttal.
Thank you. I'd like to make 2 points. First, what the prosecution is saying here, what the state is saying is, in my opinion, absolutely wrong. You do not weigh all the evidence. You can't weigh evidence that hasn't been introduced. There has to be a hearing first, then the court takes the evidence, and then the weighing process starts. What the prosecution is suggesting to you is that a petitioner would have to prove that he's innocent, without a doubt, before the court can conclude, then there'd be a hearing. That's not the standard.
Well, wouldn't it be the same standard like in a 1507 where if, you can look at the record of the trial, the record of the, everything, the pleadings, everything, and determine whether or not it's more likely than not that no reasonable juror would have convicted in light of the newly presented evidence?
No, Your Honor, I respectfully no. Then what is the point of the hearing?
So does every single petitioner that alleges actual innocence get a hearing?
Yes, if you have
Yes?
evidence, and that the petition, the affidavit from Dr. Young raises issues that, if true, and you have to accept it all as true, you do not weigh it yet, is exonerating, then you have the hearing, and then that argument can be made. I mean, I could sit here and tell you this whole charge came about because the mother had a dream, you remember that, and then read her horoscope and then questioned her daughter, who denied that it ever happened. I mean, we could go into this ad infinitum. That's not the question. The only question for this court today is there sufficient reason to conduct an evidentiary hearing? The second point I want to make is this, Your Honor, because it became important. The hearing that you talked about was May 10th, 2018. We in our brief, and we'll stand by this, it was a status conference. That's when the petitioner and his mother testified about their inability to get records. It was not an evidentiary hearing.
And where does it say it's a status conference?
Well, we're quoting, I think, from the record, but it's in record. It's record volume 2. Is that hearing?
Well, I read the entire hearing, but I also saw that the judge Sunby brought in the petitioner to testify. Is that unusual? I mean, where does it say it was a status hearing?
This was. Well, I mean, we'll research the record more. We certainly never contemplated that the court was going to see this in an actual, as that they got an evidentiary hearing. The whole point, when Reardon argued at that hearing, he said he was entitled to the photographs either under the discovery statutes or pursuant to the state's Brady obligations. That's at the record, volume 2, page 28. He then filed a motion to court to set aside HIPAA confidentiality. And the court took it under advisement. What the court was taking under advisement, I submit, was providing the photos and moving the HIPAA. It was not the evidentiary hearing because they didn't go into any of the issues.
Well, why did the judge Sunby say he was going to take it? I mean, he issued an opinion right afterwards. Not right afterwards, but
I don't disagree, Your Honor. What if you read it? If I were the defense counsel, would have thought he's taking under advisement whether he's going to give me these photos, which I need to have the hearing. You can't say you're having a hearing about getting evidence and the judge is going to rule on that, and that's the evidentiary hearing. I just strenuously disagree that is actually the evidentiary. That is an evidentiary hearing, or anyone thought it was an evidentiary hearing. So I wanted to make that point.
Okay.
I appreciate the court's time this morning. Nothing further.
Appreciate both of your arguments this morning. We'll take this case under advisement and get your opinion as soon as we can. Thank you very much.
I appreciate it. Thank
Thank
you.
you, Your Honors.
Thank you.
Thank you very much.